Good afternoon. We're delighted that you're still here, that you're alive, you're awake, and still enjoying. We have a fabulous panel now. It's been such a wonderful day. Today, the panel is titled Civility, Religious Liberty, and Non-Discrimination. Some of the most heated and ugly battles that we see in popular culture now often turn on this question of religious liberty and non-discrimination. And a discussion about being peacemakers, I think that I'm very excited for this panel and the things that we have to learn from them. I'll give you brief introductions of them so that they can have the book of the time. First, we'll hear from Tim Schultz, who's president of the First Amendment Partnership. He works with faith groups to ensure that religious freedom is protected in the law. Secondly, we'll hear from Kevin Worthen, who probably needs no introduction for this group. He has served as president of BYU and is now returned, thankfully, to us at the law school, where he's a scholar on federal Indian law and the impact of law on indigenous peoples internationally. He's also serving as a constitutional law fellow with the Wheatley Institute. And then we'll hear from Tyler Deaton, who's the senior advisor to the American Unity Fund that works at both state and federal levels to advance non-discrimination legislation by working with Republicans. He's been working with LGBTQ movement for many years, and I've had the privilege of getting to know all three of these wonderful people, and I'm just so pleased to have them here today. So we'll start with Tim and then go through as outlined.
So I am a religious freedom lobbyist and legislative strategist, and the division of labor that we have decided on is my job is to talk about religious freedom and non-discrimination, and then they're going to fill in a lot of the gaps, especially around civility in this space. And what I'm going to do in my 10 minutes is give you what I think are the 15, and I'm going to do this quickly, but the 15 most important developments over the last 2 generations in the history of religious freedom versus non-discrimination, okay? And I'm going to go at a little bit of a gallop. This is going to be a little bit of a montage, like at the beginning of your favorite television series. You know, they start each season with what happened last season. That's what's going to happen here in the next, 9.5 minutes. Okay, so 1963, the United States Supreme Court, the Warren Court, decides Sherbert versus Verner. And this is a case that the court says the free exercise of religion in the Constitution is like the other First Amendment rights, like free speech, free association. We're going to protect the free exercise of religion with the highest constitutional standard, okay? I don't need to say anything more about that, but in 1964, just the next year, Congress passes the Civil Rights Act of 1964. Landmark legislation aimed at breaking the back of Jim Crow legislation, or Jim Crow in the South, highly needed. The thing you need to know about the Civil Rights Act, though, and it's important for this future discussion, is that federal law and the state laws like it have treated different kinds of discrimination somewhat differently. They have treated racial discrimination in one particular extremely tough way. They've treated discrimination on the basis of sex, the basis of religion, in a slightly different way, a slightly more nuanced way. So that's important. Race has a unique history in the United States, and so racial discrimination of all forms of discrimination has been treated with a really big, very strong hammer by the law ever since 1964 with the Civil Rights Act. In 1982, states began passing laws that extend non-discrimination laws to those on the basis of sexual orientation, and later gender identity. But in the early days, it's just sexual orientation. And the thing about these laws is that all of these state laws, which are passing in the 80s and 90s in what we now call blue states, these laws make exceptions for religious organizations. They basically say, look, if you're a religious group that has an objection to this, that's fine. This law basically does not apply to you. And that's a kind of standard that happens in these laws beginning in the 80s all through the 90s. and these laws are passing apace over a period of time. In 1983, the United States Supreme Court decides the Bob Jones University case. In a legal crowd like this, a lot of you will have heard of this, but basically beginning all the way back in the Nixon administration, the racist policies of Bob Jones University in South Carolina force a collision between the tax-exempt status of Bob Jones University and the stated policy of the United States of America to eliminate racism in federal funding. Bob Jones ultimately loses that case in 1983. It will become very important in a little bit. But notice, gay rights laws are sort of starting to really become a thing in the early 80s, okay? Bob Jones University is this racist institution. Nobody who is passing these laws is saying, yes, the religious organizations who are concerned about these things are like Bob Jones. Like, that's not a connection that's being made when these laws are passing in the early 1980s. In 1990, you will have all heard the Supreme Court decides a case called Employment Division versus Smith. It overturns the Sherbert versus Werner case that I talked about earlier, and it says that basically unless you have an intent to discriminate against religion, there is no free exercise of religion, and you know that you can't bring a case into court on the basis of the First Amendment free exercise of religion. If you have an issue, go talk to your legislatures, go talk to the Congress, go talk to your state legislature. I think that case was wrongly decided. Fortunately, so did Congress. And in 1993, Congress almost unanimously passed something called the Religious Freedom Restoration Act. Those of us in the business call it RFRA. I think there were only 3 votes against it in the entire United States Congress. Bill Clinton signed the law. It was supported by the ACLU, the Christian Coalition, the Church of Jesus Christ of Latter-day Saints, and kind of everybody in between, okay? In 1996, responding to developments around gay marriage, the United States Congress passes a bill called DOMA, the Defense of Marriage Act. It basically says whatever states are starting to do on gay marriage, the Congress, the federal government, doesn't have to recognize those marriages for the purposes of federal law. That was also signed into law by Bill Clinton. It was passed with overwhelming bipartisan majorities. Next year, 1997, the U.S. Supreme Court has a case called City of Bernie, in which they say Congress actually did not have the power to pass RFRA and enforce it on state governments. They can do it to the federal government, but they do not have the constitutional power to enforce this against state governments. So the Congress responds by trying to repass RFRA. They try to pass a RFRA that will apply even to the acts of state and local governments. But by that time, in just 7 years, the bipartisan consensus around RFRA has broken down. They're not able to get all the way across the finish line on all aspects of RFRA. Instead, they just have something that applies to land use and lawsuits involving prisoners or institutionalized persons. We call this the Religious Land Use and Institutionalized Persons Act, aka RLUPA. That's another acronym in the business. In 2004, Massachusetts becomes the first state to pass gay marriage legislatively. And they do it using the very same model that a lot of these non-discrimination laws, which Massachusetts also had, have used. They provide religious exemptions for objecting religious organizations. And as other states begin to follow Massachusetts' example, they do the same thing. They layer on additional religious protections on top of the religious protections that they already had in non-discrimination law. In 2013, the U.S. Supreme Court decides a case called Windsor. The reason that's important is they overturned the DOMA law that I talked about having been passed in 1996, and everybody who read the opinion, was legally astute, said, Justice Anthony Kennedy is signaling that in about 2 years or so, he's going to declare a constitutional right to same-sex marriage. Of course, that is exactly what happened 2 years later in the Obergefell case. But in the meantime, many states looked at that Windsor case and said, well, we're not going to pass gay marriage legislatively. We're a red state, but what we certainly want is we want the same kinds of legal protections as all of these blue states have. States like Massachusetts and Connecticut and New York, they have religious protections. They have gay marriage. We're about to have gay marriage because of the courts, we want the religious protections too. So states set out to start trying to pass these religious protections in a standalone way. And many of you may even remember that in 2014, there was a religious freedom bloodbath. Religious freedom laws are cast as a license to discriminate. Major corporations like Home Depot and the National Football League threaten boycotts of states that pass these laws. Red state governors start vetoing religious freedom laws. And religious freedom becomes one of the most unpopular cultural flashpoints in the United States, and really the sort of first modern case of corporations heavily weighing in on highly contested social issues. So this is 2014. And in 2015, there is a kind of fork in the road where people who have a broad view of religious freedom, that is people like me and the organizations I work with, kind of have a choice. Like, are we going to try to message better and just repeat what we just did and fight a little harder, or are we going to seek civility, compromise? That was sort of those were the two paths, and those two paths were sort of on display in two different states in 2015. So Indiana passed a RFAR law. Many of you may remember it got crushed politically. Mike Pence was a political pariah for a time before Donald Trump revived his political career. Utah passed something called the Utah Compromise, and it became something of a model. Those in this audience will know a lot about it, but it became something that looked as a possible different approach, protecting gay people from discrimination, transgender people from sort of basic market discrimination, but also robustly protecting religious freedom. A lot of people looked at these two options and said that Utah approach looks pretty attractive. In 2019, two things happened. Congress, for the first time, passed a bill called the Equality Act in the House of Representatives. Not the Senate, but in the House of Representatives. It passed with a 70-vote margin, which is pretty big in the House. That same year, a smaller and kind of less noticed bill, the Federal Fairness for All Act, was introduced also in the Congress. And most people looked at that and said, look, this just doesn't look like it has much traction. It's got a bunch of Republican co-sponsors. It doesn't really seem to be something with legs, especially compared to the much bigger and more controversial Equality Act. Well, in 2022, and my friends are going to, I think, unpack this story a little bit, Congress had an opportunity to look at this legislation in light of potential threats to the repeal of the Obergefell decision. Those aren't real threats. Justice Thomas had written in his dissent, in a concurrence in the Dobbs case overturning Roe v. Wade, he had said, I think we need to start overturning other cases too, like Obergefell, for example. And so there were some folks who in the Democratic Party who said, wait, let's use this as a campaign opportunity to sort of gin up support and campaign contributions. But ultimately, that effort, which I think began as a kind of bad faith political messaging bill, ultimately turned into a massive national compromise on questions around protection for the marriages that have already happened, but also religious freedom protections enacted for the first time in the United States Congress since the Religious Freedom Restoration Act. So the model that started in Utah in 2015 became law in the United States in 2022 and was passed into law in a bipartisan way. That's the history. We're going to talk more about the kind of civility part of that, but if you kind of know those 15 sort of things, you're already kind of an expert on the law and history, the law and policy around religious freedom and non-discrimination. And now I'm going to hand it over to the professor. Oh, you love it.
Let me thank Tim for that extraordinary summary of what the law is. There are three concepts referred to in the title for this particular panel: civility, religious liberty, and non-discrimination. Unlike Tim and Tyler, I have no expertise in either religious liberty or non-discrimination. So I really had no choice but to talk about civility. I'm not really an expert on that either, but at least comparatively I have some. I want to talk about the way in which disputes between religious liberty and non-discrimination can be addressed. And in addressing this issue, I'm going to be relying heavily on the thoughts and insights of President Dallin H. Oaks, former justice on the Utah Supreme Court, law professor, member of the First Presidency of the Church of Jesus Christ, of Latter-day Saints. So I'm doing a bit of channeling for him, but I need to say this caveat. He doesn't necessarily agree with anything I'm going to say here. This is my reading of what he's spoken about over the last decade, particularly a talk at the University of Virginia in 2021. If you're looking for a source, that's probably the best one. And it really has a potential to identify rights or disputes between religious liberty and LGBT non-discrimination rights in a way that is not only civil but productive, reaching a resolution without requiring compromise of core values. Now, this approach, which some call fairness for all, is as much a mindset as it is a process. In fact, it's more of a mindset than it is a process. The key premise of this approach, now I am going to quote President Oakes. He didn't identify it as key premise, but I'm saying it's the key premise. But he did say that the goals of both sides are served not by each side seeking total dominance of their own position, but by resolving differences through mutual respect, shared understanding, and good faith negotiation. Now, there's a lot that can be said to unpack that, but I'm going to talk about 5 highlights that are interrelated features of what I'm going to call the fairness for all approach, each of which is somewhat countercultural in our current hyper-polarized, hyper-judicialized way of approaching laws. So the 5 are this. First, the parties should avoid seeking total dominance and instead seek fairness for all. This shift in mindset is pretty significant if you think about it. It requires those who have been involved to set aside habits that are often ingrained in lawyers and other public advocates. It requires that parties refrain from contesting with all their might every policy that might infringe on their rights. President Oakes stated it this way: people of faith should not contest every non-discrimination law or policy that could possibly impinge, however significantly, on institutional or individual religious freedom claims. Likewise, he continued, proponents of non-discrimination need not contest every religious freedom exemption from non-discrimination laws. Under this approach, the parties need to consider the well-being of all parties involved, including those on the other side, and they also need to include in their calculation the need for unity in our polarized society. Second is mutual respect. This requires that the parties recognize the inherent worth and human dignity of every person involved, including those on the other side. Thus, President Oakes said, they should avoid labeling those involved with epithets such as godless or bigot. And as President Oakes stated, when some advocates voice insults or practice other minor provocations, both sides should ignore them. Self-restraint not common in our multi-social media world. The third feature is shared understanding. Among other things, this requires that all involved acknowledge that there are worthy constitutional and ethical arguments on both sides, and that neither constitutional value, he said, liberty in the case of religious freedom and equality in the case of non-discrimination, is absolute. Thus, he said, those using this approach would be especially wary of the idea that one set of rights should automatically trump another set of rights in all circumstances. It is an approach that favors balancing interests rather than bright-line universal rules. Fourth is good faith negotiations. The fairness for all approach requires that there be give and take between the parties. The parties should recognize that they may not get everything they want. At the same time, they should recognize that no one will be required to compromise on core principles. If carried out in good faith and with mutual respect, the negotiations themselves will help identify and clarify what those core principles are. It will also often lead to new solutions that are not understood at the outset. Finally, this approach prioritizes legislation over litigation. While the judiciary has a role to play in our system, it is not the primary governmental actor under this approach. Courts are designed to resolve disputes involving specific parties, often in a winner-take-all ruling. In making that decision, courts are restricted as to what they can consider, being limited to the evidence presented by the parties and the record produced at trial. They are ill-prepared to create or facilitate the kind of empathetic dialogue and nuanced give and take that the fairness for all approach envisions. It's not to say that courts can't do them, but they're not in a position to generally do as well. Now, while this approach is currently largely countercultural, it is consistent with both constitutional theory and Christian theology. On the constitutional level, Yuval Levin, in his recent book, American Covenant, describes how various features of the Constitution are designed to create common ground, not just find it, but create it. And to do so by compelling Americans with different views and priorities to deal with one another in ways that not only unify society, but also lead to better results. An apt description of the fairness for all approach. As for Christian theology, Christ's teachings in both the Bible and the Book of Mormon instruct his disciples to be peacemakers, as we've heard today. Teachings that have recently been emphasized by both President Oaks and President Russell M. Nelson. As President Oaks made clear in his University of Virginia talk, this approach is not easy. It takes people on both sides who are committed to the process, even in the face of criticism from their own allies. Moreover, it is not normally a quick process. It takes time to build up the necessary level of trust, to identify and refine possible solutions, and persuade others to support the end product. President Oaks identified one example of when this approach has worked, and Tim's described it to you, the so-called Utah Compromise. President Oaks actually in a subsequent interview said he prefers the term principled accommodations. Bill Eskridge, a leading LGBT advocate, says he calls it not Utah Compromise, but the statute of principles. Many of you here are probably familiar with it. It occurred here in Utah and involved a conflict between free exercise rights and non-discrimination rights of LGBT individuals in housing and employment. It was a 6-year process, as I look at it, which began with local legislation and eventually produced state legislation, which, as they say, is often called the Utah Compromise. The legislation was endorsed by both the Church of Jesus Christ of Latter-day Saints and Equality Utah, a leading LGBT organization in the state. President Oaks described the legislation and process this way, and I'm going to quote him here because it summarizes both the process a little bit as well as the outcome. He said, "This law offered protection to both sides. One side obtained significant legal protection from discrimination in employment and housing. The other side gained protection for religious freedom in the most sensitive areas of church employment and student housing. While the law gave neither side all that it sought, its reconciliation did grant both sides significant benefits, a win-win outcome that could not have been obtained without the balancing of interests made possible by the dynamics of the legislative process." Then he said, maybe more importantly, the process provided an opportunity to forge enduring relationships. Now, after describing this success, President Oaks made the following intriguing statement, which is much a challenge or question as it is an observation. Whether this approach can be applied to other sensitive issues remains to be seen. That is an issue that is worthy of discussion today and in the future. Let me conclude with just 3 brief observations about that question. First, if the question is whether the approach can apply to LGBT and religious liberty issues other than employment and housing, the answer seems to be a clear yes. Exhibit A being the Respect for Marriage Act that we've seen, but I think it goes well beyond that. I think many of the discussions today have alluded to that. Second, if the question is, are there some conflicts between religious liberty and LGBT rights that cannot be resolved by this approach? Issues on which there is no common ground because it requires compromise on core principles. The answer is, I hope not, but I don't know. But I do say that because of the relationships that are created and strengthened by going through this process, the effort is worthwhile even if there is no successful resolution of the specific issue. Relationships matter. Third, if the question is whether the approach has possible application to disagreements on issues other than religious liberty and LGBT rights, other issues other than non-discrimination issues just in general, the answer is a maybe. In his recent book, Cross Purposes, Jonathan Rouse suggests that the various features of this approach can help set the tone for productive discussion on contentious issues and help inculcate society and the values and habits required of citizens in a pluralistic domestic principle, a republic, principles that apply well outside the ones we've discussed today. With that, I would just say again, a way that is countercultural, that is different, but has the potential to allow the resolution of issues in a more productive way. And I look forward to the discussion. Thank you.
All right, my name is Tyler Deaton. I run American Unity Fund. I when did these meetings start, the Religious Freedom Annual Review? 12 years. I think I've been to most of them, not all of them. I missed last year. I had a newborn daughter, and I definitely missed last year. I had a good excuse. But it's a pleasure to be here. It's always wonderful to be at BYU. It's wonderful to be in Utah. I've been working in Utah my entire adult life at this point. I first came out here in 2010, 15 years ago. I was 24. Working on Fairness for All, back whenever this was still sort of the local Salt Lake City, Salt Lake County level issue that some of you will remember. But I've been to a lot of these meetings, and each year I feel like we're meeting and it's a different geopolitical moment. Myself, I just got back from Alaska. I was off the grid. I actually was with a few people in this room 2 weeks ago, right before I got back. I went to Alaska. I'm back from Alaska. It was with the J. Reuben Clark Law Society in Valley Forge, Pennsylvania, which was also just this incredible experience to be in Valley Forge, talking about religious freedom and talking about pluralism. I've been to a Dallas version of this event with Bill. And we've had a lot of conversations over the last 2.5 years about the Respect for Marriage Act specifically. And I have a few additional thoughts that I think to add, other than the fact that I did just get back from Alaska. This is kind of my first day back working. It was my in-laws' 50th wedding anniversary, and being with a 1-year-old on a cruise ship is not a vacation, as it turns out. But I'm here, and I'm not a lawyer, and I'm also really not particularly civil, but I'm gonna talk about civility, and I think that people who work with me would generally agree. Like, I'm not famous for my civility. I have to do a lot of bipartisan work. I'm not that bipartisan. I'm a pretty right-wing Republican on most issues. But I also like to win. And I also believe certain Christian things about what it means to live in this democracy and to advocate for pluralism, which I believe for Christian reasons specifically. And so that's what I'm going to focus on, is what I think it means to be civil in this time. So Kevin shared something that I think, it was sort of heavy for me. I don't know if you meant it to be this heavy, but when you were quoting Jesus saying, be a peacemaker, the people who try to make peace, I think, are hated the most. And it's something that's it really sat with me whenever you shared that. It's like, being a peacemaker is not hard. It should not, it's not easy. And I guess it shouldn't be easy. It's not easy to be civil. It's not easy to be patient. It's not easy to love your enemies. And those people who are setting themselves out to speak truthfully, even to speak prophetically, I think they take the slings and the arrows. They take the hate, even as they're preaching love. They're the people who just get hated the most. And I think it's one of the reasons why it's easier to just go back into your camps. To go back and, it's got to be very comfortable to a point to be a Pharisee. It's got to be very comfortable to just be ideologically hard left, hard right, whatever, pick your flavor. It's easy, it's comfortable, it's a warm blanket. You're just going to be surrounded by people who agree with you on everything, and you're going to say things, they're going to say, yes, amen, say it again. And you're not going to be challenged by the people who disagree, and they say, well, wait, what did you mean by that? Or, hey, could we unpack that? It's a lot harder, it's a lot more work. It's also the only way to get things done in our system of government, which is the system of government that we prefer and should prefer. And so I think that that's what I've had to learn over the course of my life, is how to take strongly held values, some of which even in ourselves can be in tension with others within yourself, things that you prioritize. Even things as simple as just like, how are you going to spend your time today? Which issue are you going to spend your time on? Which person or persons are you going to spend your time with? This wasn't a calculated decision 15 years ago when we founded American Unity Fund. It was set up by some of the biggest conservative donors in the country who also believed in the freedom to marry and religious freedom. And we saw these green shoots of a conversation happening in Utah, and frankly just ran toward it. Had nothing to do with it. I would take zero responsibility for the genesis of that. There were local people working, and we're already having those tough conversations that I just alluded to, that were like meeting in living rooms and did not agree on much, and in fact, not only disagreed, but had a lot of baggage with each other, and we're still sitting around tables and having cups of tea and talking it out and finding common ground. And that, I think, those conversations in Salt Lake in 2009, 2010, 2011 are a direct line to the passage of the Respect for Marriage Act in 2022, which is at once both the most important gay rights legislation that has ever passed in the world, not in America, but like, who cares about Europe? I mean, it's the most important gay rights legislation that has ever passed. And that same bill is the most important religious freedom legislation that's passed in a generation. And I don't want to quibble over this, but I think given where we are as a society, much tougher to pass than RFAR in 1993. And so to build that coalition and to have people who really don't like each other, I'm trying to tone it down, I would normally say hate each other's guts, but people who really don't like each other, working together, finding common ground, a particularly courageous senator from Arizona, Kyrsten Sinema, particularly courageous LGBT activists on the left who really stuck their necks out. Like for me, being gay and being a gay Republican, like I'm already sort of tribeless in some parts of my life, and so I don't really lose anything if I make the Human Rights Campaign or the ACLU angry. But there are a lot of LGBT activists who I work with, some of whom have spoken here, some of whom I think have maybe one of my friends spoke earlier today. They really put themselves professionally and personally on the line for religious freedom. And it gets back at that earlier point about being a peacemaker and being prepared to take the arrows. And it's not fun. It's not really my comfort zone. It's not what I'm best at. But I think it's what we're called to do and to be. And so I appreciated that you shared that. And that's how I interpreted it. It's just like to think of the end of that story, of what it meant for Jesus to be preaching peace and what it means today, I think, for people to be advocating for peace in this world. And of course, here we're talking about peaceableness in our law, but there's also real challenges for, real war and peace around the world today. And so I would just finish with that, which is that I'm taking the question of civility and peacemaking and zooming out. And if I had to then just sum it up in one word, it would be allyship, which is that I feel like as a gay man, and I am a Christian, but still just in this world that we live in, I think it's hard to hold both of those identities in the public square for most people, I guess. And I've tried to be an ally to people who are much more conservative than me and who disagree with my marriage. And to me, that feels like real allyship, that I am defending the rights of people who do not agree with my marriage, but I'm working with people who do not agree with my marriage who are defending my human rights. And I think that there's a lot of allyship that's needed right now. I think the Jewish people are front and center for me as I'm thinking about threats to pluralism or peace in our world, and threats to our way of life and the things that we value. That's really heavy on my heart too right now. And so I would just encourage everyone to find the ways in your own life that you can be a little more uncomfortable, be a little more aggressive in search of peacemaking, because I think that this is, I don't know if there's a joke on that. I'm really bad with like phrases and aphorisms and things like that, so there might be one and Tim can help me out, but there's something about moderates are usually, not only are they moderate, they're just like bad at politics. They're mushy not only about like the views, but they're also mushy about the tactics. And I don't want any of you, as we're talking, because I think it could get a little bit like, oh, woo-woo, like pluralism, peacemaking, like we all love each other. No, we have real disagreements in this world. We believe in pluralism. We've got to be aggressive for pluralism. And so whether you think of that as moderation or whatever words you want to put on it, you've got to find the ways to put yourself out. And if you're not taking slings and arrows, then you're probably not actually doing anything for peacemaking and pluralism. So that's the finish.
Thank you. Well, I appreciate this panel. This is just a wonderful combination of perspectives and views, and really grateful to all of you.
Thanks.
I've got two questions, and the second one I'm going to come back to Kevin's question about, can this apply elsewhere? Just put that in the back of your brain for a minute. But first, I want to think about this idea. I've talked to many people of different faiths who are deeply uncomfortable with the legislation that was passed in Utah. And I think this comes from both sides, I would guess, from what you're saying, Tyler, that you have people who, for lack of a better word, feel complicit, right? Some of it may be just political posturing, right? I don't want to be seen as sullying myself with the other side. But some of it's real, principled views of, I care about this, this is a principle. If I do anything to deviate from this, I'm compromising these core principles, whether they're LGBTQ rights, whether they're religious freedom, and religious commandments about chastity and sexuality. How you've all been involved in this process. I mean, and Kevin, you've been involved with lots of people along these lines. How does that conversation go when you're trying to talk to them? If they feel that they have some kind of deep-seated, it's part of, that the command to be a peacemaker, for example, is in tension with other things that Jesus said about keeping the commandments, right? How do you unpack that with people?
I mean, so look, I work with lots of faith groups that that I agree with on like 99% of things, and this particular question of how much to compromise on LGBT rights, non-discrimination, is one that has divided a lot of serious, faithful people. And it's actually my favorite part of my job is that I get to work with faith leaders and individuals from lots of different faith communities, and I see the best of them. The least favorite part of my job for me is arguing with people that I respect and that have a really broad shared view of religious liberty with me. So I actually really dislike that part of my job. And and that is exactly what people say. And my response is that, like, complicity is not the only moral principle. So on the one hand, yeah, like the whole idea of conscience is that we don't want to do things that violate our conscience, that cause us to be complicit in something. People don't want to, bear arms in some cases in service of their country. That's why we have conscientious objection, right? Like they don't want to be complicit in a killing. We understand that very well, but that complicity is what's really behind that. But complicity is not the only moral principle, right? It's certainly not in Christianity, not the only moral principle. There's also just an idea of like the common good and sort of mitigation, right? There's lots of ways in which we see, both in the Old and New Testament, God accommodating himself in some ways realistically to the evil of the age, right? I mean, when Paul writes about slavery, which of course was a moral abomination, and the kind that was practiced in the New World in the United States was an absolute moral abomination. But he's writing in the Roman Empire at a time when the idea that they were this little kind of quaint sect, they weren't going to abolish slavery in the Roman Empire in the first century, right? It took a while for that to unfold. But like, there's certain ways in which you do accommodate yourself to the culture, the realistic culture that you live in, and you seek to mitigate the moral damage of things that you think are wrong. So that's another principle in Christian ethics that goes all the way back to Paul's writings in the first century about ethical matters, right? So I just think that's what I would say, but I'd still say you shouldn't violate your conscience, right? But I think it's still important to like interrogate your conscience and say, wow, is this conscience, or is this just, I just disagree with you about a political call that you're making here? And I also think, and I've said to some of my friends here, like, you can't elevate every disagreement about political tactics to like this is a matter of grave conscience, and you're sinning, and I'm saved. You know, I think that's also another error that some people also make. That's my answer.
Thank you.
I'll just share a couple data points.
Please.
Not that that's the whole story, but it's part of the story. The law's been on the books now for 10 years. We worked with the state's Office of Civil Rights, which may not be exactly the right term, but we worked with that office to find out what has happened with the implementation of this law. And there have been a completely predictable, proportional to the population size, number of cases of gay and transgender employees saying that they've been discriminated against. The statistics of how those cases have been adjudicated have been identical to the broader pool of race and sex and religious-based discrimination cases. Which means they slightly favor the employees more than the employers, but not overwhelmingly. Most of these cases are settled. Most of the employees go on with their lives. And that's just a small data point of showing like the law has worked. And so I'm not hearing those complaints myself from employers or from landlords or the people who've been implicated directly by those laws. But I understand this point about complicity, and I think it's a tough one. I think that it's a bigger, sort of a first order question that can also, by the way, cut to just what do you think about protecting religious minorities themselves, right? Like there's some complicity in that, in protecting the religious beliefs of people who believe radically different things than us. And I believe this is a multi-faith event. I think there's a lot of us that if we started talking theology have huge disagreements over who people are in this world, and that's okay. I want to have that same standard applied in a reasonable way to adults who are gay and transgender, and I think that that's why the law has worked, is that it has been consistent with previous decades of application in civil rights law, and it had all of the appropriate, well-crafted, targeted exemptions for religious employers and religious landlords and small employers and smaller landlords, et cetera, et cetera, et cetera, that makes the law work. And so my last data point is just this. And I'm going to give 2 data points because the second one I don't love, but I'm going to share it anyway. The first one is that Utah is now tied for the top 3 states for support of non-discrimination laws in the whole country. It's up there with Vermont and New Hampshire. It's ahead of California. It's ahead of Hawaii and Massachusetts and other really, really blue states in support for non-discrimination laws. So the law has been very popular at the broad-based public opinion level. What has not shifted? Support for traditional marriage. Utah is still in the top 3 in terms of support for traditional marriage. And so you have this interesting electorate that this is still a state that believes in traditional marriage, but also believes in fairness for all. And to me, that's another data point that it's working. I think it doesn't answer that. It's a very philosophical question about what does that mean to, codify a protection for a class of people. I get that. I think that that's an important philosophical question that we should wrestle with. I just think it's already been answered when we decided to protect religion itself as a class.
I mean, that is, and I don't want to jump on anything Kevin's going to say here, but I just think that I'm a Christian, right? And when I find out that somebody's an atheist, I start scheming to convert them, right? I want atheists, just full stop. If you're an atheist here, would like to talk to you on the side about, possibly asking Jesus into your heart before today is over, because I believe that's what everybody needs to do, okay? However, I don't want atheists discriminated against in employment at Home Depot, okay? I don't want that to happen. I don't want that. That would be discrimination on the basis of their religion. If they're seen by their employer as being on Facebook on an atheist site, I do not want them fired. I don't believe that's complicity in their profound religious error, right, that is going to have them on the wrong side of eternity. I can believe both things at once, that they are profoundly wrong in their theological beliefs, that they need to convert and follow the Messiah Jesus, but I don't want the law to coerce them into that at all, right? And so I think that principle of non-coercion applies in a great many things, and I think it applies arguably in this space, at least some parts of the space around LGBT issues as well.
Yeah, I'm going to say, I think part of it is really sort of dialogue again. I mean, so much of this comes back to conversation, including the one with being complicit. And starting with the same model that I envision with the Fairness for All, which is you start with common ground. And then sort of work from there. What do we agree on? And then through that process, you identify core principles. And quite often through that discussion, people will recognize that part of their objection to same-sex marriage or relationships really is just sort of cultural. It's sort of a reaction that gets reinforced in social media, and they'll start thinking, well, if we're ahead of California on something, that's bad. Yeah. And that's kind of the angle they take. And having discussion with them in which you say, was that really a core principle? And getting back to what is it we disagree about, and sometimes we'll just disagree. But I think if you do that and do it in a way that identifies that common ground and causes people to think, and for us as part of the dialogue, it's not like I've got the answers to talk through it and identify where the core principles are. I think that can alleviate some of it in terms of saying, well, at least I understand your motivation. Because I think that's probably, if I were to sum up the biggest mistake that I make and others I observe sort of make is we don't assume good faith. And I just keep reminding myself, we create narratives about why people think what they think and who they are based on one example or one factor that we have. And just say, well, assume they're God's children, which we believe, with inherent ability to become, with a divine potential, which we believe. And say, so why would we assume that it's bad faith? Let's assume they are people who are trying their best and doing that. It's surprising to me, it's kind of like a Sunday school answer, but I found it to be pretty effective in terms of people even dealing with the ones in terms of where they feel complicit or that compromise has been made on a core principle.
Mm-hmm. I appreciate that. It reminds me of when I was reading it says you could sort of tell someone's political leanings by asking them what car they drive or what kind of coffee they drink, or sort of one of a number of questions that we automatically sort of sort. All right, so I know we don't have much time left, but I'm going to jump to the next question. I know, for example, the Church of Jesus Christ of Latter-day Saints at one point encouraged legislators in Utah to come together and try and find common principles about, say, immigration. And I'm wondering, some of the principles that we've been talking about today, if there's other areas that you can see where, whether it's within sort of LGBTQ rights and religious freedom or more broadly, that they might apply.
It seems like immigration would be a good one because part of it is to say, how is this affecting people? And not an undifferentiated mass, but talking about individuals, even if they're hypothetical individuals, about how do you feel if you're here, you grew up in the United States, if and just sort of explore those ideas in terms of that. If it's that kind of issue where it really involves people, I think there's room for common ground. It's what we were talking about, what you were talking about at lunch in terms of saying, identifying sort of harm to individuals with stories. But then they can say, that really, for me, identifies an area in which you say, this approach could work in that area. If it's sort of, the longer it remains sort of abstract disagreement about some fundamental policy, and maybe that's what the core difference is and you have to live with that, that's the part where I start wondering, I'm not sure this fairness for all will work because nobody sees the unfairness to the other side.
This is true. Other thoughts?
It isn't so much that I think I think immigration is a good one to talk about. I think that one of the kind of underrated things that's happened as a result of, the Fairness for All kind of Respect for Marriage Act is that a lot of the faith groups, and these are the groups that I work with, hadn't really worked together that much before. I mean, they would sign briefs together and stuff, but they didn't necessarily know each other at a deep level. And so I would say now there's a kind of responsible faith coalition that's kind of floating out there thinking about common good type issues that they can work on together, and that they've kind of gained relational capital through their work together on these non-discrimination issues. And so these are issues like AI policy. They're issues about like the challenges of boys and men in our culture and especially in the education system. Tech issues about how do we protect kids from harmful tech. There are a few others, but I think that these are issues that faith groups that have it's kind of a common sensibility on the issues that were kind of under discussion on our panel. They kind of find that sensibility also kind of flows into other issues, and they're kind of beginning to work together on those as well. So I think that isn't really an issue where you have two sides clashing and kind of finding some sort of, kind of common ground. It's more like people of common sensibility that haven't worked together that much are now kind of like, we have a common sensibility on some of these other social problems. Let's like try to solve these as much as we can. That's where I actually think the action's mostly going to be.
That's fascinating.
Yeah.
Sort of was discussed in the last panel, certainly, this idea of coming together.
Yep. Tyler?
All I'll add is that there's a lot of groups that exist to be uncivil. And on immigration, name all sorts of issues, but immigration is one of them. I used to work on immigration, worked a lot on refugee resettlement issues, specifically worked on a lot of the kind of the technical aspects of immigration. When we passed the COVID stimulus package, we had this absurd provision that said that if your spouse was undocumented, that you also didn't get your stimulus check. I mean, there's just like things like that I've worked on. And after that little back and forth, I was like, I gotta step away from this issue, because on everything that I worked on, it wasn't opposition on the right that was killing the possibilities. It was opposition on the left. And I think that we had this incredible coalition that came together on the Respect for Marriage Act that took years and years to build, that had enough commitment from the center left and the center right to kind of push off those extremist forces. And I don't see that coalition on some of these other issues. And so that's what I would want to highlight.
Not on immigration.
Not on immigration. And in fact, there are far left groups who just don't want there to be a deal. And I mean, obviously there's far right groups too. I mean, I'm just assuming we all understand that. But I saw that up front trying to cut these deals, that it would be people kind of ostensibly on my side of the table killing every possibility, including, the most bipartisan package that came together in the last generation, again, that did not pass, that got huge Democratic and Republican support, was opposed by Kamala Harris when she was still U.S. Senator from California for entirely political reasons. And this was the McCain bill that some of you might would have remembered. There's like this huge vote-a-rama under Trump whenever there was a moment where we almost passed the DREAM Act. And so I don't share that because I'm not disillusioned by any of it. I would love to go back to work on that with the clarity and the conviction that you have to build this middle out. And I think that there were enough people interested in doing that on Fairness for All. And I don't have a complete answer on that, other than that I think it was a personal enough issue for enough people and families in America that they were invested in reconciling these tough questions of religion and sexuality. And I don't see that constituency yet on immigration. I think it could be built. I'm seeing one of the most interesting things that I saw out of these, it's been a horrible news week for so many reasons, but seeing some of these protests, one of the interesting things that I saw, and it really stuck out, was children of immigrants showing up at these rallies. And to me, that's actually new. And I feel like I've seen a lot of I'm not that old, but I'm old enough. I've been around the block. I've seen these protests. That was new. And I think if the children of immigrants start to show up, there could be a coalition there of reasonableness and of people who actually want to find a solution. But right now, Elizabeth, I would be convinced on most issues, we could go down the line, there's not actually that coalition for a solution.
I mean, it's a combination of there being a coalition that kind of builds out from the center in both directions and kind of political incentives aligning. We don't, at peacemaking conferences, we don't like to talk as much about the sort of gritty realities of politics. But I mean, the RMA doesn't pass unless there's sort of two things happening, political incentives. On the left side, you just have people who are like genuinely want gay people to feel affirmed by a federal law that's going to say, you know what, your marriage is valid no matter what the Supreme Court does, and that's going to mean a lot to you. And so Chuck Schumer has a gay daughter. Tammy Baldwin, who led the effort in the Senate, is lesbian. It's personal. And on the right, they just wanted this issue off the table. They just did not want to get beat up by it, and there was just a political incentive. I mean, I think 12 Republicans voted for it in the Senate, but I think 35 wanted it to pass. Right, and then that's also an underrated fact. You have people who vote yes, you also have people who vote no but hope yes. right? And that don't really do anything to oppose you, right? I mean, it was just noteworthy that, like, during the whole process, one of the most sort of vociferous no guys in Washington, D.C. is Ted Cruz, right? Senator Ted Cruz, like, he's always going to run up there and say, Ted Cruz didn't say jack about the Respect for Marriage Act. Well, you know why? Because he wanted it to pass. Now, that's wild to think that, right? Ted Cruz, yeah, Ted Cruz didn't say a word. Ted Cruz never fails to say a word if he wants to say a word, right? Right, it's because he wanted it to pass. And that political alignment is also necessary for these, like, great compromises to ever happen. So, yeah.
Well, I wish we had more time. We could go on and continue the fabulous discussion, but our time is up. So please join me in thanking our panel.
Thank you.